Generally speaking, there are four kinds of things that states may not do under the Constitution. Two of them we tend not to spend too much time on in our constitutional law courses, maybe because they're so straightforward. But just to mention them, first, states are forbidden expressly and specifically from doing certain things by the very terms of the Constitution. For example, states can't coin money. If you look at Article 1, Section 10, there are a variety of specific limitations on what states can't do. And as I said, one of them is they can't coin money. We couldn't have every state having its own monetary system, obviously. Then, second, there are things states can't do unless they get congressional permission. States, for example, can't wage war without congressional consent. So if Maine wanted to go to war with Canada, for example, they might be able to do so, but Congress would have to approve. States can't enter into contracts or agreements with other states without congressional consent. States can't tax imports or exports, and there are a variety of things that states can't do because they are forbidden unless Congress consents. So those are two kinds of limits. But the two more important, that is to say at least more complicated, more intricate kinds of limits are, first, things that states may not do because the state law or the state regulation or local regulation conflicts with or obstructs federal law. Under the doctrine of supremacy of federal law, under Article 6, federal law, if authorized by the Constitution, prevails over any conflicting state law. If there's a conflict, the federal law wins. Now, maybe one way to think about this is from a game that maybe you played when you were a child. It's a game, I don't know what it's called, but it involves paper covers rock, rock breaks scissors, scissors cut paper. Well, federal law beats out state law every time. And in terms of supremacy, any time that you find a conflict, you just leap to the conclusion that federal law prevails. Now, that principle can be stated fairly easily and straightforwardly, and I suppose it is simple and straightforward. The harder question is under what circumstances the state and federal law actually conflict. Well, there's the very easy case. If you have a situation where Congress says that its law is supposed to prevail over state law, that's what Congress said, then state law has to give way. Another fairly easy case is if you have an out-and-out direct conflict on your facts. Even if Congress hasn't said that its law prevails over state law, it does by virtue of the conflict. For example, let's say federal law required cars to have rubber bumpers, and state law required that they have metal bumpers. You couldn't comply with both rules. There's a direct conflict, and state law has to yield under the doctrine of supremacy. But sometimes the more difficult questions arise about conflict. One area, for example, is under the doctrine of preemption. Let's say Congress has passed a regulatory statute, a broad-based regulatory scheme in an area. And let's assume Congress didn't say anything about what the states could or couldn't do, and the states also want to regulate in that area. Is the fact that Congress regulated extensively in that area an implied conflict with states also being in the area? Did Congress mean for the states to get out of the area because Congress is occupying the field, as we say, and the state has no room there? Well, you don't know. It's a matter, really, of legislative interpretation. And in the course of legislative interpretation, you try to figure out what Congress intended. Now, sometimes the court, in trying to figure that out, relies on values that it believes are implicated in terms of federalism. For example, if the subject matter is one, let's say, that relates to national security, or that really requires a national response or a uniform rule, then doubts about preemption will be resolved in favor of preemption. On the other hand, if it's an area where states have traditionally regulated, then preemption won't be as readily found. Now, at other times, you can have a conflict between state and federal law where you don't have a direct conflict, but state law frustrates the carrying out of federal policy. And that can be enough to invoke supremacy of federal law, making state law give way. There are a lot of potential examples here. Take as one a state food labeling law. Let's say you had a state food labeling law and a federal food labeling law. Even though the federal food labeling law didn't say anything about ousting state law, and even though there was no direct conflict, maybe one of the purposes of Congress in passing its law was to simplify labeling on foods. You know what it's like when you go into a store and you read the pricing labels and the nutrition labels and all the rest of that are on commodities. Well, maybe Congress wanted to prevent a proliferation of labeling as much as it wanted to provide information. So you might say, in that kind of a case, while there's no direct conflict, state law would frustrate the actual carrying out of federal policy, and that would be enough. So in this area, there's really not a lot more to say, except to make the observation that federal law is supreme over state law. State law can coexist with federal law if it's complementary to or supplementary to federal law, and that's what you would argue if you were trying to uphold it. And certainly, state law can exist if Congress says that the state law can exist side by side with its regulations. But on the other hand, if you want to argue to strike down the law, look for conflict, a direct conflict where you can't comply with both, or an indirect conflict where the state law frustrates carrying out federal policy, or an indirect conflict in the sense that if you have Congress passing an extensive regulatory scheme that seems to occupy a field, then that thereby implies that the state should give way and get out of the field. Okay, now I'd like to turn to the fourth kind of prohibition on actions by states under the Constitution. And this area is even more intricate and probably more interesting. And it's the area where you've probably spent a lot of time. Indeed, I'd say about this area that you probably spent a lot more time than we can certainly give it here on these tapes. We're going to summarize a lot of what you've done. And as in other areas, I hope you don't feel too badly about that, because although you have spent a lot of time, you've probably been engaged in the historical development in this area. And for our purposes, we can just cut to the chase and identify the rules as they are now, with a snapshot of the law instead of a motion picture of everything that took place before. And the area that I'm talking about is where acts of state and local governments are prohibited, not because they conflict with federal law. There aren't any federal statutes on the topic, but they're prohibited from enacting laws just because the Constitution gives Congress power to regulate in the area if it wanted to. So even if Congress doesn't use its power, there are what we call certain negative implications from the grant of power to Congress that limit state power. And the area that I'm talking about and that you have undoubtedly studied is the so-called Negative Commerce Clause, or the Dormant Commerce Clause. It's dormant because you don't have a conflicting federal law yet. You just have the state law. The mere fact that Congress has been given broad power to legislate under the Commerce Clause happens to carry some limitations automatically applicable to states and the laws that they pass that affect interstate commerce. Now, the Negative Commerce Clause doesn't oust states entirely, but it ousts them to some degree under rules that we have to identify. Before I tell you what the basic rules are, you can see how there's a tension here and why we're trying to work out something in an area where you have two sovereigns legitimately at work. On the one hand, Congress is given this broad power over interstate commerce, and the framers wanted it so. Under the Articles of Confederation, we had a terrible situation where states were basically at economic war with one another. And so with the new Constitution, we wanted a single national response to interstate commerce activity. By the same token, however, a lot of interstate commerce activity, of course, takes place in states. And states have a need to regulate what goes on in their borders. They have a need to tax. They have a need to attend to a whole variety of problems. And these problems may intersect with commercial activities, regulation of the roads and stores, for example. So the question is, how do we work out the needs of both the federal and state government in this area? And the basic rule of the Commerce Clause, the Negative Commerce Clause, comes down to this.